Hi, I'm Fran Shopik. I'm here to present for the Litigation Survival School to Pierce County Law Library. Before I get started, I want to take a moment for disclaimers. The first disclaimer is to say that this presentation is for educational purposes only, and that's true of all the presentations from the Litigation Survival School. It's for educational purposes only. We will not be giving legal advice as part of this presentation, and nothing in this presentation serves or substitutes for legal or clinical advice. What we say today likewise does not create a legal or clinical relationship. This means that we do not represent you in your litigation and we are not acting as counselors. Recording or photographing is not allowed. We're here today to talk about vocabulary in the court, because when you go to court, you're going to find that certain things sound like the words that you understand, but they don't mean the same thing. So we want to help you do that. So welcome to court, to that foreign land where you go to fight for the things that you hold most dear, even though you don't know the customs or the language. In other words, potentially this is a living nightmare. In order to go to court, you have to understand that it's complicated under the best of circumstances. And if you didn't go to law school for 3 years, you're going to need help. In fact, even if you did go to law school for 3 years, if you were doing your own case, if you were I'm going to explain as pro se, you would want help. Which is why we're here. We want to help you get through this experience. It's important to understand that going to court is a marathon, not a sprint. So you want to save your energy and spend your resources carefully, whether those resources are emotional, psychological, or financial. You want to be very careful about how you spend them. The process is traumatic, whether you filed first or not, even whether you win or lose. It's an upending experience and you will need support to get through it. One of the biggest challenges is to understand what's going on, to literally just understand the words of what's going on. So it can be helpful to think of court as a foreign country where words sound the same as what you're used to, but they don't mean the same thing. And this is the kind of thing that nightmares can be made of, because you're actually thinking, what does that person mean when they say something to me? You've crossed over into another world and you need to know the language. So just like when you go to any foreign country, you can either learn the language yourself, or you can have someone with you who can answer questions, or you can find a dictionary. None of those one things in and of itself can be the perfect answer, because even if you learn the language yourself, there might still be things that you need help understanding. But the Litigation Survival School is a little bit of all three of those things, and we hope to help you through the experience. You think you know the language already, but you need to think again about that, because there are things called false cognates. False cognates are words in one language that are similar to words in another language, but carry a very different meaning. One example is the word, if you wanted to say to somebody that you were feeling embarrassed, let's say you're in France or in Spain, and you wanted to say you're embarrassed, and you kind of figure the word embarrassed, embarrassé would be the same thing. So you might say, je suis embarrassée in French, or estoy embarazada in Spanish. But what you would be saying is actually, I am pregnant, is what you'd be saying, not I'm embarrassed. So you would want to know these things, because it can be really important to communicate what you need to say. When you're in court, you don't get two chances, or you might say something that misrepresents what you actually mean. A term of art is a word or expression or phrase that has a particular meaning in a particular context, which is different from its usual meaning. And that some of those examples, which I'm going to explain in a moment, but just so you know, some of those examples are the words like continue, or holding, or motion, or party. So let's get started with a few meanings that will help you to be familiar with. The first one is court, since that's the basic idea that we're talking about. It's really important to know that the word court can refer to several things. First of all, it can refer to the judge, the actual person of the judge. If you say the court made a decision, that means that the judge made a decision. The court process as a whole is another way that court can be used. Like, I want my day in court is saying that it's referring to the whole process, not just the judge. It can also refer to the courthouse itself. Like if you said, where's the court? I'll meet you there. That's referring to the courthouse. And you always want to actually go in advance and make sure you know where you're going and where the actual court will be, that your matter will be presented. It's also important to realize that when you write the word court in court papers, you want to capitalize it. So if you said, I hope the court rules in my favor, that would take a capital C. The word litigation. Litigation refers to fighting in court. Now, you turn to the law when you and another person can't agree on something. If you could have figured it out on your own, then you would have figured it out on your own. So when you go to court to present your version of events to convince the court of your version of events. So basically, if you're in court, by definition, it's going to be adversarial. Litigation has lots of rules to follow, but make no mistake, it's a battle. And you need to know the rules. A litigant is a person who is fighting over something in the lawsuit in court. It's also referred to as a party to the case or a party. Litigants are opposing parties to each other. A party in real life, a party is a social gathering and hopefully it's fun. But in court life, which I'm going to say ICL, in court life, a party or a party to the case is a person or entity who takes a side in a lawsuit. And it's also, that person is also referred to as a litigant. When you hear the word pro se, and if you go without a court, without an attorney, if you go to court without an attorney, you are pro se. In Latin, it means for oneself or on one's own behalf. So that's a party who represents oneself in court without a lawyer. A third party refers to a party or entity who is not a party to the case. So that just means if you have the two parties to the case, it just means a third party is the person who's not a party to the case. The moving party is the party who initiates a motion. An emotion, in real life, emotion refers to physical action or moving back and forth. But in court life, emotion is very specifically a request that is brought to the court. It is a question that the litigant is asking the court to resolve. And when you file a motion, you ask the court to consider your request. A hearing is when you go to the court to ask it to make a temporary decision during the months or years before knowing the court's final determination. And the court's final determination will be made at trial. So for instance, it can take quite a while to get to the final trial. And during that time, you'll have lots of questions that you want the court to decide. Like if it's family court, you might want a temporary parenting plan to use until the final decisions are made. And those things would be made through motions that are brought to hearings, and the temporary decision is made at the hearing. A holding is a legal principle to be drawn from the opinion or decision of the court based on the issue presented. A court's answer to a question of law. And it could be a decision made by a higher court that tells your court, the lower court, what to do, and it establishes the principles for your court to follow when it makes decisions. So this is both a false cognate and a term of art. The counsel or counselor is an attorney. It's the person from whom a party may seek legal advice or guidance, but it's also the act of offering legal advice or counsel. An opposing party is the other party in the case who opposes you. So each party is the opposing party to each other. An opposing counsel, likewise, is the attorney called the counsel or counselor who represents the opposing party in the case. And both attorneys are opposing counsel to each other. To allege means to assert or claim a fact to be true, but you can't say that it's true until the court has made a decision. Once that's said, then you can actually assume or proceed as if it were true. But up until that point, you're only alleging. And an allegation is an assertion or claim or accusation that is not proved to be true. To continue is a false cognate and a term of art because it sounds like something different, and it's also particular to court where this meaning is used. In real life, to continue means to keep moving or to persist at something, but in court life, to continue means to stop or postpone an event, such as a hearing or trial. If somebody says we're going to continue the trial, that means that it's going to be at a later date, or we'll continue the hearing means it'll be at a later date. Discovery refers to a stage of litigation. It's the discovery stage of litigation, but it also refers to the act of reviewing information. Discovery is the time when, among other things, first of all, each litigant gets to ask questions that the other litigant must answer, and also when each litigant can ask for evidence that the other person must give, that the other party must give. Evidence refers to proof intended to convince the judge or the jury of alleged facts that are important and relevant to the case. They can be in lots of different forms. Evidence can be presented in different forms. Oral testimony, when what someone has to say, can be used as evidence, and those can be fact witnesses or expert witnesses, which we'll explain at a different time. Evidence can also be in the form of documents or public records, objects like a blood stain or a fingerprint, photographs, or depositions. And a deposition is a testimony under oath that's taken before trial, but it's not a formal trial, but it's under oath, so it's in some ways it has the same standard of truth. A sanction. So this is a sanction. This is a false cognate and a term of art and what's called a contronym. The word sanction actually means its own opposite. So it can mean, in real life, it means both to approve or endorse, and it means also to penalize. You could say, for instance, sanctions included awards and other honors, but you could also say the wrongdoings were sanctioned with a fine or a loss of license. But in the context of court, sanction means to punish or to penalize for wrongdoing. Now, service, in real life, service usually means to perform an act that another person wants or has requested. You do them a service, you do something for them. But in court life, service is very specific, and it refers to a specific act of giving someone else legal papers in a specific way that meets the court's specific requirements to prove that the person got the papers and when. The person being served may be the opposing party or a witness for the testimony. If the service isn't done properly, it might mean the person hasn't been served. It's as if they never received the notice. So it has to be done in a very particular way, and it has to be done properly. It's going to be important for you to understand that if you are receiving service or providing service. To stay is an action taken by the court to stop or delay a legal proceeding or the actions of a party. To argue, in real life, the word argue has a certain connotation of a heated exchange, but in court life, it just means to try to convince. It means to present your case, to give reasons for or against a matter that's in dispute, as opposed to merely just showing the evidence. When you argue something, it's called argumentative. And argumentative just means that you're pleading your case. Again, it doesn't have to mean that you're insulting anybody or that it's a heated discussion. It just means that you're pleading your case. To note, in real life, to note means to acknowledge or to be aware. It can also be a message that you send. But in court life, to note means to enter a matter on the court calendar, to note it. I want to take a little bit of time with objections. The form you've often heard on, everywhere, TV, movies, I object. So you object in court when you want to stop the action. You want to stop everything so that you can get a ruling on what's happened. So it's either to say that a lawyer's question is improper or to stop a witness from talking. You want, before the witness answers, you might object to the question, or to say that a witness's answer is improper. When you object, everything needs to stop until the court rules to either agree or disagree with the objection. It can be really important to make a timely objection so that you can preserve the matter for later review, such as an appeal. So what that means is that if something is said in court and you're thinking, well, that's not right, I want to object to that, but I'll wait until later because it would feel impolite to object right there, then you lose your opportunity to preserve the objection. You have to make the objection right away, and you have to make it even before a person answers a question so that the judge can make a ruling. If you object to it, even if the judge doesn't agree with your objection, then it will be something that if you wanted to appeal it later, it would be preserved for the record and you could appeal it. But if you don't object, then that kind of means that you've accepted it and you are willing to go along with it. So you won't be able to appeal it. Common reasons for objections are relevance, hearsay, something's prejudicial or speculation, privilege, lack of foundation, argumentative, badgering, asked and answered, and improper form of question, leading or compound. And I'm going to explain what each of those is. So when you object, the court is going to make a ruling. If the judge says that the objection is sustained, then that means that the judge agrees with you and that the action should go no further. So if you object to a question and the judge agrees with you, they sustain the objection, then for instance, a witness won't be able to answer the question. If the judge says that the objection is overruled, however, that means that the court does not agree with you and your objection doesn't count. It's going to be overruled. So then the witness would go ahead and answer the question. Relevance is really important because everything brought up in the court needs to be relevant. If it's not relevant, proceedings could take forever. So sometimes there will actually be an objection just on the grounds of relevance. If it's not relevant, the evidence could be used for shock value, which would be improper, and the procedure would be rendered inefficient. So it really needs to always be relevant. A question could be relevant, but relevance could be outweighed by prejudicial value. So meaning it could be relevant, but if it's so prejudicial to the case, which the judge would make that determination, then it might not be admitted. And that's when you talk about probative versus prejudicial. If it's probative, meaning it's useful or it helps understand the question, versus how prejudicial it might be. Hearsay isn't, technically speaking, the way it's defined is that it's an out-of-court statement made in court, offered to prove the truth of the matter asserted. Out-of-court statement made in court, offered to prove the truth of the matter asserted. Basically, what that means is that hearsay is what someone might hear from another person, and then they say it as if they know it to be true. And some people would call it gossip. But if you hear somebody say something like, someone told me this, then it might be hearsay unless it meets an exception. Hearsay is a type of testimony that's not permissible in court, but there are many exceptions that could apply. So there might be ways to get around it. If you were speaking in court and the other counsel or the other person said that it was hearsay, you might then be able to say, yes, but there's an exception to hearsay. You would explain what the exception is, and then it might actually be allowed. Someone says that it calls for speculation. So in general, a witness is expected to answer questions based on their observations and known facts, things that actually happened. If they're asked a question that requires speculation, such as guessing or drawing a conclusion that goes beyond their own personal observation, then the counsel could object. Some witnesses may be permitted to speculate, but generally speaking, if you speculate, meaning you're drawing your own conclusion, then you may not be permitted to offer that conclusion. Privilege refers to matters between an attorney and client that are protected by attorney-client privilege. Witnesses do not have to answer questions that refer to matters discussed between the lawyer and client. So if someone said to you, what did your attorney tell you? That's privileged information. And you need to know that it's privileged, because if you go ahead and answer that question, then you've waived your privilege. So privilege is the client's to waive or preserve, not the attorney. Another ground for objection might be lacking foundation. So before you ask a question, you need to establish a foundation to show that the witness has personal knowledge of the matter. For example, if you want to ask a witness about another person, you'll first have to establish if the witness knows the person in question or how the witness knows the person in question. It might actually be both, if and how. When you talk about something being argumentative, the question makes an argument rather than asking a question. So that could be another ground for objection. Badgering is where a counsel is antagonizing the witness, such as by provoking, mocking, giving no time to respond, or using sarcasm. Asked and answered is an objection that is used a lot if the question has been in fact asked and answered. So there are times that a witness may answer a question, but the person asking expects, or they try to force a different response by asking the same question in a different way, or by pushing, such as, really? Is that really the case? Or are you sure? Or they'll just ask it in different words. So this is actually a form of badgering. You can object by saying that the question has been asked and answered. Sometimes another thing that they might do, although it's another way that they might try to get another response, is to just wait and depend on your willingness to come up with another way of answering it. An improper form of question is a leading question. One example is a leading question. That is a leading question is a question that has a yes or no answer, the kind of question required for cross-examination. It leads the witness to the desired answer, such as, isn't it true that, or didn't you do such and such, or something happened, didn't it? And then the person, it's a yes or no answer. It's not something that is open to further discussion. Improper form of a question, there can be a compound question, such as a question that embeds more than one question, two or more questions into one question. So an example might be, when did you decide you wanted to leave the marriage? This has 4 embedded questions in it. It presupposes, first of all, that the person decided. It presupposes, secondly, that the person wanted to leave the marriage, and third, that they wanted to leave, and fourth, that there was a marriage in the first place. So the proper form would be to lay a foundation for each premise. And then the last thing is that I want you to be familiar with a few abbreviations, like ER refers to evidence rule, CR is the Superior Court civil rules, and RCW is the Revised Code of Washington, which are the laws of this state of Washington. This last one, RCW, each state will have a different way of expressing that, but in Washington, it's RCW. You'll see those letters a lot, and it's really good to know right away what they mean. And thank you for listening. I hope this has been helpful. If you have more questions, we're happy to answer them in our presentations at different times. And thank you to the Pierce County Law Library for having us.